And greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, hit that like, share, and subscribe button. There is a PayPal link down there for anybody who wants to share some love. And I'm going to get into it, talking about the government representative trustee and how you're financed to debt. It's the identification that I keep telling you about, the state ID, the driver's license, the birth certificate, social security card, the enumeration at birth, and how it provides a presumption in the record that you're a person reasonably believed to be an eligible contract participant. So let's take a look at it. And we're going to start out with 31 U.S. Code 5318, compliance, exemptions, and summons authority. This is money and finance, Title 31. General powers of secretary. The Secretary of the Treasury may, except under Section 5315 of this title and regulations prescribed under Section 5315, except as provided in subsections B2 and H4, delegate duties and powers under this subchapter to an appropriate supervising agency and the United States Postal Service. So again, I'm telling you folks, this is all a matter of the accounts of the United States Postal Service and that general ledger, and they're the ones that are responsible for reconciling any out of balance accounts. And it goes on to say, require a class of domestic financial institutions or non-financial trades or businesses to maintain appropriate procedures, including the collection and reporting of certain information. Okay. This is where you're required to keep that record. So when you get a bank account, you're required to keep a accounting yourself. You get a social security card, you're supposed to be keeping an accounting of all of the documents and transcriptions and prescriptions or subscriptions or ascriptions that you apply that social security number to, and you're supposed to be putting those in your own record file bureau. As the Secretary of Treasury may prescribe by regulation to ensure compliance, to ensure compliance. And that's not enforce compliance, because compliance is not enforceable. Compliance is assent. Okay. With this subchapter and regulations prescribed under this subchapter, or to guard against money laundering, the financing of terrorism, or other forms of illicit finance. Owe no man anything but to love one another, for to love one another is to fulfill the law. So why is everybody claiming to be the debtor? Why is everybody claiming to owe something? Because they've been put through a form of illicit finance, the identification process, the enumeration at birth, wherein a third party is created, separate from the first person and second person. It is a third person, much like Tom Sawyer, a complete fiction. Examine any books, papers, records, or other data of domestic financial institutions or non-financial trades or businesses. Again, remember the definition of trade or business is the performance of the functions of public office as it relates to the United States and taxes, relevant to the record keeping or reporting requirements of this subchapter. Summon a financial institution or non-financial trade or business. No one else. So that identification is implying, again, like I said, that a person reasonably believed to be an eligible contract participant in a financial institution or a non-financial trade or business. One or the other. An officer or employee of a financial institution or non-financial trade or business, including a former officer or employee. Or any person having possession, custody, or care of the reports and records required under this. So when you get that Social Security application, you send that in, they send you a Social Security card. Guess what that is? You are now a custodian of a record. You have in your possession a card that has data elements and information on it relative to a non-financial trade or business. And it implies that you are acting as an officer or employee in financial transactions with other financial institutions. To appear before the Secretary of the Treasury or his delegate at a time and place named in the summons, and to produce such books, papers, records, or other data, and to give testimony under oath. Did you take an oath? Can they compel you or require you to take an oath? They can certainly compel you, but can they require you to take an oath when the scripture says you are not supposed to do so? As may be relevant or material to an investigation described in subsection B. Exempt from requirements, We're going to go on down to limitation of summons powers. The Secretary of the Treasury may take action or take any action described in paragraph 3 or 4 of subsection A only in connection with investigations for the purpose of civil enforcement. Remember we said ensure compliance? See, that's a pre-action. You do the contract to clarify things to ensure that the actions will then be followed. If the actions are not followed, then they have a right to go and try to enforce them, so long as all the data elements are true and correct, are facts in law, and not presumptions. A person reasonably believed. You have to quit believing, folks. And again, I'm telling you, don't believe me. Don't believe the neighbor. Don't believe the government. Don't believe your mother, for crying out loud. Do your own research so you know. Of violations of this subchapter, Section 21 of the Federal Deposit Insurance Act, Section 411 of the National Housing Act, or Chapter 2 of the Public Law 91-508, which is 12 U.S.C. 1951 at sequential, and we'll be taking a look at those for their scope of power. Very imperative to look at this section and at sequential. It's going to tell us all kinds of things. It goes from 1951 to 1960. So there's literally 10 sections we're going to look at, and there's only going to be 3 of them that we're actually going to look at any kind of depth. The others, we're just going to look at the titles, and the titles will tell you a lot. But again, don't believe me. Do your research. I'm just skimming through this, hopefully to give you some kind of implication of what's going on. Authority to issue. A summons may be issued under subsection A4 only or with the approval of the Secretary of Treasury or supervisory level delegate of the Secretary of Treasury. So if you're getting a summons from an administrative judge, then he can only be acting under a delegate level of authority, supervisory of the Secretary of Treasury. Remember, the resident is no person shall be allowed to reside within the zone except federal, state, or municipal officers or agents. That's those officers or employees of the state, federal, or local government deemed necessary by the board. And the board is the Secretary of Commerce as the executive chair and the Secretary of Treasury. So it's the resident determination is one of those things that I'm talking about with the ID at the state level. We're going to talk about that a little bit again later. Then we see administrative aspect of summons. That's why I say that administrative law judge, he's doing it in an administrative aspect of summons. Production at designated site where the resident is located, the local official or agent. That's what the presumption is, folks. You got a state ID. you're in custody of a certain piece of material that has data elements on it that imply that you're a person reasonably believed to be a eligible contract participant. A summons issued pursuant to this section may require that books, papers, records, or other data stored or maintained at any place be produced at any designated location in any state or in any territory, the special maritime territorial jurisdiction of the United States, or other place subject to the jurisdiction of the United States, not more than 500 miles distant from any place where the financial institution or non-financial trade or business operates or conducts business in the United States. Fees and travel expenses, no liability. Service of summons. Service of summons is issued under this section, may be by registered mail or in such other manner calculated to give actual notice as the secretary may prescribe by regulation. And again, this is why the Postal Service is involved. It includes the postal rule. Contumacy or refusal. Now, contumacy means compliance. When you look up to contumacy, I'm pretty sure you're going to find the word comply, to comply, something like that. Referral to Attorney General. In case of contumacy, compliance, by a person issued a summons under paragraph 3 or 4 of subsection A, or refusal by such person to obey such summons, the Secretary of Treasury shall refer the matter to the Attorney General. This is where I'm going to talk about that personal jurisdiction that we've discussed before, that it is voluntary. Once the plaintiff, you see, in order for the court to obtain personal jurisdiction, the plaintiff must serve the defendant in the state in which the court sits, first and foremost. And so it's a two-part thing. Upon the summons, which they're supposed to provide a waiver of personal jurisdiction so that you can waive that person over to somebody else that can hire an attorney through a board of directors, which you cannot because you're not a corporate entity. Unless, of course, you are a corporate entity and do have a board of directors, then you can hire your own private attorney. But this is personal jurisdiction cannot be obtained unless it's voluntarily appear in court. Jurisdiction of the court. Pay attention, folks. The Attorney General may invoke the aid of any court of the United States within the jurisdiction of which the investigation which gave rise to the summons is being or has been carried on. So the investigation, and it's a summons to look at a record, no matter who's holding it. But if I'm not the one holding it, then I have to direct them to the one that is. Because that's what they're doing, is they're investigating the record. Again, I remind you, the individual's name and social security number identify the social security record. Therefore, the driver's license and the name and number on the driver's license identifies the driver's license record. State ID, the name and number on the state ID identifies the state record. The name and address identifies the residential record. The person summoned is an inhabitant, or the person summoned carries on business or may be found to compel compliance with the summons. Not enforce compliance, compel. Again, personal jurisdiction, you must voluntarily appear in court. You need to voluntarily appear in court after you receive a summons. And remember, that summons has to be valid. In other words, it has to be through a certain process of service through the Postal Service or any other service has delegated, being a certificate of service by a private party even, showing evidence that the service was given and there was receipt. And in that summons, there was also a waiver of personal jurisdiction so that remedy can be had in the proper process. Otherwise, the service of process is not due. Court order. The court may issue an order requiring the person summoned to appear before the secretary or his delegate to produce books, papers, records, and other data. So if they're looking for the person, which is the individual, and they're identifying him by a name and a number, then they have to go to that record. I don't hold a social security card. I don't hold a bank card. I don't hold a state ID. I don't hold those. I don't have possession or custody of any of that kind of stuff. I hold a PayPal card, which is evidence as a benefactor to a third party, or as a benefactor for a third party debt process. The contracting parties are already there. Bancorp is the account origin. They have the account of which they extended in a contract to PayPal to open up multiple sub-accounts. PayPal also has a contract with MasterCard to issue the cards for those accounts. Or his delegate to produce the books, papers, records, and other data to give testimony as may be necessary to explain how such material was compiled and maintained. I gave it to him. I'm the one that was a bitch-ass slave, a fucking fool, and gave him that information, said I was a resident, only because I was indoctrinated by other people that did the same thing and told me that's the way it's done. That's the way it can be done. But there are still certain requisites that must be confirmed. Otherwise, the record still remains a presumption and not a fact in law. Therefore, the integrity is not upheld. Failure to comply with order. A failure to obey the order of the court may be punished by the court as a contempt thereof. Remember, this is the under administrative aspects of a summons and the service of that summons under the administrative aspects. There's no other way to do it. That's why they have to have the ID to make sure they're serving the right person. That ID shows that you are in custody of the material needed to go forth with that suit. Written and signed statement required. No person shall qualify for an exemption under subsection A5(1) unless a relevant financial institution or non-financial trade or business prepares and maintains a statement which describes in detail the reason why such person is qualified for such exemption and contains the signature of such person. This is what I'm talking about with the declaratory judgment here recently, is that you have to declare that you have certain exemptions or exceptions. Definitions and application. Financial agency means a person acting for a person. A person acting for a person. You cannot be a person, folks. So let's continue on. See, I don't think there's much else on this one that I wanted to get into. There is something down here, I think. Can't remember. Oh, what was it? Anyway, you'll see it has to do with anti-money laundering, anti-kickback laws, and trading with the enemy, laundering foreign currencies, things like that as we go through here. I think that, yeah, I'm pretty sure that's it with this one. So let's go to the one I just popped up, 31 U.S. Code 5312, definitions and application as it relates to the very compliance, exemptions, and summons authority. Compliance, exemptions, and summons authority is under definitions and application. So, in this subchapter, financial agency means a person acting for a person, except for a country, a monetary or financial authority acting as a monetary or financial authority, or an international financial institution of which the United States government is a member. As a financial institution, bailee, depository trustee, or agent, or acting in a similar way related to money, credit, securities, gold, and transaction in money, credit, securities, or gold, or a service provided with respect to money, securities, futures, precious metals, stones, and jewels, or value that substitutes for currency. Acting in a similar way. Are you on the other side of that counter at a bank? Acting in a similar way as a banking institution by filling out data elements that they need on their financial documents? Is that not acting in a similar way? By giving them financial information so that they can imply that you are the debtor? Financed to debt. Financial institution means an insured bank of the Federal Deposit Insurance Act under 12 U.S.C. 1813. That's where we find the definition of deposit. 12 U.S.C. 1813, as well as a like, almost verbatim with an extension on there as to primary obligation or obligor and secondary obligor, such and such, under 12 CFR 204.2. Again, another definition of deposit. I urge everybody to look those up. A commercial bank or trust company, a private banker, an agency or private banker. See, that's that guy on the other side of the counter of the teller. He's acting in a similar way. They're a public banker and acting in a similar way, but as a private man, you are in equal consideration a private banker conducting banking activities. Any agency or branch of a foreign bank in the United States, any credit union, a thrift institution, by providing that social security number, it is a thrift trust, a thrift fund trust, a thrift institution. A broker or dealer registered with Securities and Exchange Commission of the Securities Act of 1934, which is 15 U.S.C. 78A. I urge everybody to go look that up. A broker or dealer in securities or commodities, and that's where that a person reasonably believed to be an eligible contract participant, and he's participating in commodities and exchange contracting. Contract is the law. Even if it's just an application, you're presumed to be in a contract. You're giving information of contract, offer and acceptance in formation of contract. An investment banker or investment company, a currency exchange, or a business engaged in the exchange of currency, funds, or value that substitutes for currency or funds. Are you acting in a similar way? An issuer, redeemer, or cashier of travelers' checks, money orders, or similar instruments. An operator of a credit card system. If you're using that credit card, you are an operator of a credit card system. An insurance company, a dealer in precious metals, stones, or jewels, a pawnbroker, a loan or finance company, a travel agency, a licensed sender of money, or any other person who engages as a business in the transmission of currency, funds, or value that substitutes for currency, including any person who engages as a business in an informal money transfer system or any network of people. How many times do you see this word in their code? or any network of people who engage as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institution system. A telegraph company, a business engaged in vehicle sales, including automobile, airplane, and boat sales. A person involved in real estate closings and settlements. The United States Postal Service. An agency of replace the term agency with resident. A resident of the United States government or of a state or local government carrying out a duty or power of business described in this paragraph. Resident, 19 U.S.C. 81 lowercase o, resident. No person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. A casino, gambling casino, or gambling establishment with an annual gaming revenue, any business or agency which engages in any activity acting similarly, which the Secretary of Treasury determines by regulation to be an activity which is similar to, related to, or substitute for any activity in which any business described in this paragraph is authorized to engage, or any other business designated by the Secretary whose cash transactions have a high degree of usefulness in criminal, tax, or regulatory matters. Pay attention here, folks. Monetary instruments mean United States coin and currency, as the Secretary may prescribe by regulation, coins and currency of a foreign country, traveler's checks, bearer negotiable instruments, bearer investment securities, bearer securities, stock on which title is passed on delivery, and similar material. That Social Security card, that birth certificate, that driver's license, that employee ID, that school ID, that band around your wrist at the hospital. It's all similar material containing data elements of letters and numbers construed in a foreign grammar that you don't understand and need to ask questions about in order to find out what it means. And when you ask those questions, most of the people you ask don't know the first thing of what they mean. You have to ask repeatedly of all the way up the chain. And many times you never find out. Non-financial trade or business. Again, trade or business is either financial or non-financial, but as trade or business is, it still remains the performance of the functions of public office, which, like I've said many times, requires an oath. So if they give you a citation and then demand that you produce records, I am trying to point out that you have already have to have taken an oath in order for them to be able to force it. Otherwise, it's merely a compliance by voluntarily appearing and then taking an oath and swearing to tell the truth, the whole truth, and nothing but the truth. And how can you when you haven't done so far yet? Because you don't know the truth. Again, folks, I was a bitch-ass slave. I was a fucking fool. I used to do it all the time. Yeah, that's my name. So let's look at the next one. This is an interesting one. Number 5, person. In addition to its meaning under Section 1 of Title 1, includes, which means it excludes all else, a trustee, a representative of an estate, and when the secretary prescribes, as I mentioned earlier, subscribe, prescribe, ascribe, that's what that application is. Social Security application, enumeration at birth. Those are all subscriptions, prescriptions, ascriptions. A governmental entity. Look at that state ID right on the top of it. It says State of Iowa. That is a governmental entity. And accordingly, it's got a residential address on there along with the record name and number. So now you're providing a governmental entity as a representative of the estate on that material, and somebody else is going to act as the beneficiary and therefore put you in the position or disposition as a trustee, even though you're not qualified. You've never taken an oath. Can't do that, folks. That's your true crime, bearing false witness upon yourself. Know thyself. Certain institutions included in definition. The term financial institution includes the following. Includes the following means it excludes all else. Any futures commissions merchant, commodity trading advisor, or commodity pool operator registered or required to register. This is saying, or required to register, saying that you may not be registered, but you are required to register. And that's that Commodities Exchange Act, where that person reasonably believed to be an eligible contract participant has been found not to be registered yet and hasn't taken an oath. So we're going to take his ass to jail and fine him. And if he speaks out against it, he's in contempt, because he's already been compelled to appear in court as if though he's a slave, and therefore he is. Okay. So let's look at the next one, that 31 U.S. Code 5315 it was talking about. Reports on foreign currency transactions. Not foreign deposits, foreign currency. Remember what we just read there? Let's go back. Including any person who engages as a business in an informal money transfer system, or any network of people who engages as a business in facilitating the transfer of money domestically or internationally outside of the conventional financial institutions. Is that not private barter? Are they not conflating person as any network of people? Remember, 1 U.S.C. 1 talks about singular meaning plural and plural meaning singular, male meaning female and female meaning male. Isn't that insanity? If you're going to enter into this insane network, you better know what the hell you're doing. You better know thyself and how to separate the first person, second person, and third person, just like Samuel Clemens did with Mark Twain and Tom Sawyer, as it reflects through the record. Who's holding it and who established it? Who gave them the data elements to begin that? Mom and dad. Mom and dad then indoctrinated yourself into the public education system, or through the public education system, to then instill in you, institutionalizing you into the institutional system. Okay, so let's go back. Reports on foreign currency and transactions. Congress finds that moving mobile capital. Doesn't that sound vehicular? Doesn't that sound like a motor vehicle? Can have a significant impact on the proper functioning of the international monetary system. We are dealing with the International Bank of Settlements, or the Bank of International Settlements, which was established in the Trading with the Enemy Act back in 1936 or something. I don't know. It was along in with the New Deal, where they created the central banking system that we now have. That's what Jekyll Island was all about with G. Edward Griffin. He spoke about how they institutionalized the central bank system here in the Americas as part of the world central bank system. Okay. It is important to have the most feasible, current, and complete information on the kind and source of capital flows. Including transactions by large United States businesses and their foreign affiliates. On the kind and source of capital flows, not money, not currency, capital flows. See, this is those 1031 exchanges I was talking about, 26 U.S. Code 1031. Exchanges of property for investment or production or productive use. This is where they take the private property of the people and convert it to public property of the person. Additional authority should be provided to collect information on capital flows. This is the data elements that you're giving them and how it relates to the ID and under Section 5B of the Trading with the Enemy Act. Okay. It shows that you're domestic with the state. You're an employee as an officer or agent of a state, federal, state, or local municipality as a resident. And Section 8 of the Bretton Woods Agreement Act. In this section, United States person and foreign person controlled by a United States person. Foreign person controlled by a United States person. Does that sound like two persons? Does that remind anybody? Does anybody think about the 14th Amendment in dual citizenship there, where you have a resident of the state that is controlled by the United States person? Secretary of the Treasury shall prescribe regulations consistent with subsection A of this section, requiring reports on foreign currency transactions conducted by a United States person or a foreign person controlled by a United States person. See, the state resident is established upon enumeration at birth, which is a 5 U.S.C. 301 regulation, minimum birth registration standards. The registration is registered or birth is registered at the state, but it is a United States requirement. Therefore, it is a foreign person controlled by a United States person. Okay. So let's go to the next one. And that's the 12 U.S. Code 1951, Congressional Findings and Declaration of Person. And we're going to skip up on through 1951 to 1960, but we're going to look at 1951 here, Congressional Purpose, read it. Then we're going to read 1952, and then we're going to go through some definitions under 1953, and then we're just going to skim the titles of 54 through 60 to show you what they're talking about in basic context. It says here, Congress finds that certain records maintained by businesses engaged in the functions described in Section 1953B of this title have a high degree of usefulness in criminal, tax, and regulatory investigations and procedure, service of process. The Congress further finds that the power to require reports of changes in ownership, control, and management of types of financial institutions referred to in Section 1952 of this title may be necessary for the same purpose. Criminal tax regulatory investigations and proceedings. That's their purpose. Okay. It is the purpose of this chapter to require the maintenance of appropriate types of records and making of appropriate records by such businesses. And you are making a record with a business. And it is the business's responsibility, not yours. However, because you take upon the acceptance of certain custodial maintenance, now you're maintaining a type of record and acting in a similar way as a business, and therefore you are presumed to be a person reasonably believed to be an eligible contract participant in the contractor, in the contract as a federal, state, or municipal officer or agent, because you gave them a resident ID to do so. You already showed them that you were in custody of material, similar material. They too carry a state ID. Okay. So let's look at 1952 then first. Reports on ownership and control, where the secretary determines that the making of appropriate reports by uninsured banks or uninsured institutions of any type with respect to their ownership, control, and managements and any changes therein has a high degree of usefulness in criminal, tax, or regulatory investigations or proceedings. That's in relation to those summons. They're summoning the record and anybody that holds the record. If you're not a holder of the record, then they can't summon you. He may by regulation require such banks or institutions to make such reports as he determines in respect of such ownership, control, and managements and changes therein. He may by regulation require such banks or institutions. Are you a bank or such institution? If not, then where does his authority come from if it's not delegated here? If that administrative law judge is fining you as an estate trustee by providing that government entity, then he has every right to do so. Understand it is your fault for not understanding yourself and what you're doing. You did it. You have to undo it. (1953) Record keeping and procedures. Regulations. If the secretary determines that the maintenance of appropriate records and procedures by an uninsured bank or uninsured institution or any person engaging in the business of carrying on in the United States any of the functions referred to in subsection B, performing the functions of trade or business, or performing the functions of public office, trade or business, financial or non-financial, acting in a similar way, providing similar material, referred to in subsection B, has a high degree of usefulness in criminal, tax, or regulatory investigations and proceedings, and that given the threat posed to the security of the nation on and after the terrorist attacks against the United States on September 11, 2001, such records may also have a high degree of usefulness. So they want the person and the record. And again, the individual's name and social security number identify the record. So the person that they're looking for is within the record. If you give them the state ID, it shows that you are acting as the trustee, a representative of the estate, providing a government entity the ID. That's the Trading with the Enemy Act part. To require, retain, or maintain with respect to its functions as an uninsured bank or uninsured institution, or its functions referred to in subsection B, any records or evidence of any type which the Secretary is authorized under Section 1829B of this title to require insured banks to require, retain, or maintain. And so again, require insured banks. If they're requiring insured banks and they're using it to require, retain, or maintain with respect to its functions as an uninsured bank or uninsured institution, or its functions referred to in subsection A acting in a similar way, or excuse me, subsection B, to maintain procedures to assure compliance. Now it's to assure compliance, not ensure, because now the insurance has already been taken care of. And now you are going to assure compliance because you are in custody and show that you have already complied, even though you're not required to. With requirements imposed. That's an imposition. It's an imposition. This is an impost. Congress shall lay and collect taxes, duties, excises, and imposts. Because you're not standing as equal station in life. You're not demanding an equal post. For the purpose of any civil or criminal penalty, a separate violation of any requirement under this paragraph occurs with respect to each day in each separate office, branch, or place of business in which the violation occurs or continues. Office, branch, or place of business. For crying out loud. If you're homeless, unemployed, how can they enforce? Because the imposition is the holding of a state ID. Even the homeless are told you need an ID to get services. That's not good faith and fair dealings of a public service, which is a public trust, who is supposed to provide gifts and gratuities to the beneficiaries of the public, those in need, particularly. Institutions subject to record-keeping requirements. Understand 5 U.S.C. 552A, records maintained on individuals, and 5 U.S.C. 301, departmental regulations where minimum birth registration standards are not met. But that is the establishment of the individual known as a resident, and the records are maintained at the state level under administrative presumptions. Acceptance of automated records. It's all an electronic system now, folks. The Secretary shall permit an uninsured bank or financial institution retain or maintain records referred to as subsection A in electronic or automated form, subject to terms and conditions established by the Secretary. Subject to terms and conditions established by Secretary. 48 CFR 52.212-5 under federal acquisitions regulations. Contract terms and conditions required to implement executive orders and statutes, commercial items, commercial goods. There must be a valid contract. You cannot just be a person reasonably believed to be an eligible contract participant. There must be a valid contract fulfilling good faith, fair dealings, equal consideration, equal benefit, and if there be any detriment, that too be shared in equity so that no one be put out. Okay, that's 1953. So let's look at 1954 as it relates to the title. Injunctions. Whenever it appears to the Secretary that any person has engaged, is engaged, or about to engage in any acts or practices constituting a violation of any regulation under this chapter, he may, in his discretion, bring an action. I'm sorry to report, but I am not an eligible contract participant. I don't have an oath to perform the functions of public office to then be licensed to carry on under an insured or uninsured financial or non-financial material function. I am one of the people. I have a force majeure, a greater power to be able to speak this stuff into the record. I've been putting it into the record all my life, and that was in error. And now that I know the truth and how to tell the truth, I can just speak it into the record. I am not the trustee under an estate being administrated in probate. I'm actually the benefactor to the beneficiary. In the proper district court of the United States or the proper United States court of any territory or other place subject to the jurisdiction of the United States. See, it's got to be subject to the jurisdiction of the United States, not the state. Where the hell did the state get that they have sovereignty over the person when it is actually an enumeration at birth process regulated by the Department of Defense, which they gave up their sovereignty for the military protections of, for that corporate enjoyment. That's all it is, a corporate enjoyment. They do not have rights, privileges, freedoms, or liberties in person. To enjoin such actual practices, and upon a proper showing, a permanent or temporary injunction or restraining order shall be granted without bond. A force majeure greater than the bond. Upon application of the Secretary, any such court may also issue mandatory injunctions commanding any person to comply with any regulation of the Secretary under this chapter. So again, if the Secretary doesn't have authority over yourself, can the administrative courts compel you to do so as well when they get their delegated authority from the Secretary? No, they can't. Okay, let's look at number 55. Civil penalties. So when they go outside the bounds of the contracts that they're already in, public service contracts, which is a public trust, and deny the benefit to the one who's supposed to receive it, then there can be civil penalties. That's a Fourth Amendment violation, Fifth Amendment violations, Sixth Amendment, and Eighth Amendment violations of unlawful takings of persons without just counsel and doing it under their own presumed authorities of attorney, of authored powers of attorney, whatever they think. It's all fiction, folks. Let's look at the next one. 1956, criminal penalty. So if they go beyond their functions of office and they create a violation of constitutional equivalency, like we're talking about, then you can go after them or criminal penalties going beyond their judicial powers and actually causing harm, damage, and injury to not just your person, but to your own well-being as one of the people. '57. Additional criminal penalty in certain cases. Whoever willfully violates. So once you give them notice and they say, fuck you, you don't know what you're talking about, and refuse to do their ethical research to determine whether you're actually telling the truth or not, because it is the integrity of the record that they're supposed to uphold. And they still continue on, and they continue to violate and cause more harm, damage, and injury, not just to your person, but as one of the people, or willfully causes a violation of any regulation under this chapter, Section 1829B of this title, or Section 1730D of this title, where the violation is committed in furtherance of the commission of any violation of federal law. So again, when you're establishing the fact that an enumeration at birth and the birth registration isn't fulfilled according to the requirements of law, then the identity and any oath or license and therefore cannot be valid until that is done. The record itself cannot maintain or does not attain and therefore cannot retain and maintain integrity. The record is in error. I will not say this enough. Punishable by imprisonment for more than not for more. It says punishable by imprisonment for more than 1 year shall be fined not more than $10,000 or imprisoned not more than 5 years. So 1 to 5 years. This is misfeasance of office first. Malfeasance of office after you give them notice. Now they can suffer the 5 years. Misfeasance is the criminal under 56. Malfeasance is the additional criminal penalty in certain cases. In other words, you've already given them notice of their criminal acts, and they continue to act criminally. So now you have additional criminal penalties that you can enforce. 58. Compliance. The secretary shall have the responsibility to assure compliance with requirements of this chapter, which are requiring what? Insured banks and financial institutions. Nothing else. And may delegate such responsibility to the appropriate bank supervisory agency or other supervisory agency. That's the administrative law judge. He's the one at the local level administrating and advising or supervising the supervisory agent for the residential record that you keep giving them the ID for. And it always has your address on it, despite whether it's a school ID, an employee ID, a state ID, a driver's license, or whatever. You're attaching that address. That's the Postal Service. And I'm going to talk to you about the Selective Service, gentlemen, and how there's an agreement with the Postal Service, because that's where you go to file and register for Selective Service, gentlemen. You go to the post office, right? Same with the passport. The secretary may rely on examinations conducted by a state supervisory agency of a category of financial institution. That state administration is a financial institution. Court registry investment system. If the secretary determines that a category of financial institution is required to comply with this chapter in section 1829 of B of this title, or the state supervisory agency examines the category of financial institution for compliance, examines the category of financial institution for compliance. See, you have to be some kind of financial institution. You have to agree to either be the debtor or be the creditor that is going to pay the debt for that debtor. Know thyself, folks. You keep complying with them as the debtor. Owe no man anything but to love one another. For to love one another is to fulfill the law. (1959) Administrative Procedure. The administrative procedure and judicial review provisions of this of subchapter 2 of chapter 5 and chapter 7 of title 5 shall apply to all proceedings under this chapter, section 1829B of this title, and section 1730D of this title. Remember that chapter 5 and chapter 7 of title 5? Chapter 5, 5 U.S.C. 552A. Records maintained on individuals. (1960) Safe harbor with respect to keep open directives. What is safe harbor? Safe harbor is an exception to the anti-kickback laws for financial institutions. In this section, the term financial institution means any entity to which section 1953B of this title applies. Let's look at that 1953B again. Institutions subject to record-keeping requirements. The authority of the Secretary of the Treasury under subsection A extends to any financial institution other than any insured bank and any insured institution and any partner, officer, director, or employee of any such financial institution. And when you're standing on the other side of the counter and partnering up with them by doing their paperwork for them, you are acting in a similar function. Okay. With respect to a customer account, a customer transaction of a financial institution, if a federal law enforcement agency, after notifying FinCEN of the intent to submit a written request to the financial institution, that the financial institution keep that account or transaction open, referred to in this section as a keep open request, or if a state, tribal, or local law enforcement agency with the concurrence of FinCEN submits a keep open request, the financial institution shall not be liable under this chapter for maintaining that account or transaction consistent with the parameters and timing of the request. This is what I'm talking about in correcting the record, to keep an open account, but I am no longer liable for maintaining that account. Why? Because it's not my responsibility. It is already an undertaking of the state, and they are required to maintain it, not me. No federal, state department, or agency may take any adverse supervisory action under this chapter with respect to the financial institution solely for maintaining that account or transaction consistent with the parameters of the request. So, consistent with the parameters of the request, all I am required to do is give a name, first and last, and birth date. If I am subject to it. If I'm not, then there is no requirement to comply. I can only be compelled. Rule of construction. Nothing in this section may be construed to prevent a federal or state department or agency from verifying the validity of a keep open request submitted under subsection B with the law enforcement agency submitting that request. To relieve a financial institution from complying with any reporting requirements, including the reporting of suspicious transactions under section 5318G of Title 31. This is that section where they talk about the $10,000 deposits and the Trading with the Enemy Act and making sure that somebody is not laundering money in such large quantities. But to launder money in smaller quantities, there are safe harbors for anti-kickback laws. To extend the safe harbor described in subsection B to any actions taken by the financial institution before the date of the keep open request to maintain a customer account. To maintain a customer account, not a debtor account, not a trustee account, not an agent account, nothing else. A customer account, because the customer is the one that customizes it. After the termination date stated in the keep open request. So effectively what's happening is we're going to resign from agency as resident. We understand we are not a resident. We are not qualified to be a resident. And therefore, we're going to hand over the residency to the United States to combine that person in title and surrender it to the United States on account of the United States and in the interest of the United States to keep open the account, but remove the liability under full acquittance and discharge for the person making the same, so that no person shall be held liable in any court. 50 U.S.C. 4305B2. An open directive. Keep open directive under full acquittance and discharge for the person named as the same in the interest of the United States and for the account of the United States, so that no person shall be held liable in any court. It's a safe harbor. It's an exception to the rule, because I am an exception, because I am not the person. Letter termination date. For the purpose of this section, any keep open request submitted under subsection B shall include a termination date after which that request shall no longer apply. Record keeping. Any federal, state, or tribal or local law enforcement agency that submits to a financial institution to keep open requests shall, not later than 2 business days after the date on which the request is submitted to the financial institution, submit to FinCEN a copy of the request and alert FinCEN as to whether the financial institution has implemented the request. Contract terms and conditions required to implement statutes or executive orders, commercial items, commercial goods. Federal acquisitions regulations, 48 CFR 52.212-5. And this is why I've been screaming for a number of years. The certification is false. The financial institution has not been properly instituted. Has not been properly implemented. The offer and acceptance information of contract is not valid. It is only implied. So let's take a look at the next one. I'm sorry about the background noise. My companion doesn't understand that I'm doing a video here. Hold on.
don't even know how I got on there.
My apologies. So last but not least, 31 U.S. Code 51 or 5318A. Remember I spoke about that 18 U.S.C. 7, Special Maritime Territorial Jurisdiction of the United States, and how it applies to financial institutions, trade or business, performing the functions of public office, that oath and all that. Special measures for jurisdictions, financial institutions, international transactions, and types of accounts of primary money laundering concern. International counter money laundering requirements. The Secretary of Treasury may require domestic financial institutions and domestic financial agencies to take one or more of the special measures described in subsection B if the Secretary finds that reasonable grounds exist for concluding that a jurisdiction outside of the United States, one or more financial institutions operating outside of the United States, one or more classes of transactions within or involving a jurisdiction outside of the United States, or one or more types of accounts is from a primary money laundering concern in accordance with subsection C, and that would be the Social Security account, an account of the state foreign to the United States, which has an agreement with the United States under the 10th Amendment of the Constitution of the United States to take upon certain delegated powers that are not included in the United States nor denied by the United States, and therefore delegated to the United States or the people. Special measures. The special measures referred to in subsection A with respect to a jurisdiction outside the United States, financial institution operating outside of the United States, class of transaction within. See, the transactions are all within the United States. It is only the United States that provides the money, coin, currency, and as we talked about earlier, even through the state institution gives you material that you possess and have in your custody that relates to the dual citizenship of a person controlled by a United States person. And that's all done through the record keeping and reporting of certain financial transactions. Let's see, we got Luke Roxlock stopped in. Greetings, brother. Appreciate you. We got Ligma FPV. Hello, friends. Hope everyone is happy, healthy, and prospering. May love be upon you. We've got Creative Life says hello. Joshua Jonio, Deuces Tecum. Yes, Deuces Tecum bringing forth the record. Iman Bey says 34 CFR 40501. Relative to a program authorized. It's the system authorizing the programming. Michelle Brim asks, how does one get the exception or exemption? You have to understand who yourself, who oneself is relative to that person. You are not the person. You cannot be the person. Okay, you cannot be the name. The name is hearsay. You have to understand you're the living soul, and everything that record was extended by your parents and yourself. If not for you, it doesn't have any credence. So you have to correct it for the credence that you gave it being false. You are not of the capacity knowingly, intentionally, and willfully bearing false witness against yourself, saying that you were a resident. For income tax purposes or under the federal code says no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board. Not voluntarily offered up. Equity does not aid the volunteer. You subjected yourself to administrative procedure that you're not required to. And you only compel yourself to comply because you think the tax man is going to come after you. Once you're able to realize that you're not subject to it to begin with, then they can't compel you to appear. Yes, and it goes to eligibility. Eligibility to be able to contract. Title 34, Subtitle 4, Criminal Records and Information. 34-40903 definitions. Look these up. This is talking about contracts, Title 34. I don't know that I'm going to get a passport. I'm certainly working on diplomatic transit documentation, showing my diplomatic etiquette as a living soul with an equal station in life, and being able to post things diplomatically. Post. It's an action. It's a verb. To post something. You type something down on Facebook and then you hit a button that says post. What you're doing is taking private data elements of a journal and entering them into a commercial ledger. It says Facebook.com. On their side, they're ledgering it. On your side, it's just private data elements, a journal of your journey as a sojourner. There's an automatic conversion to a representation of value. 18 U.S.C. 8, 18 U.S.C. 7, Special Maritime Territorial Jurisdiction of the United States, and 18 U.S.C. 8, Obligations and other securities of the United States, includes, in a very simple statement between two commas, stamps and other representatives of value. So when you put these data elements on Facebook and text and then hit that enter, that's a representative of value. You have to understand how it works. You've entered in data elements. That's why they ask you for your legal name for Facebook. I went through that. That's why I put Keith Little and then in parentheses, El-Hotep II-Wee-Pharaoh. Yeah, now they understand I'm the first person I'm the first person just like Samuel Clemens. But I define that in a different grammatical style. And then on Facebook, they have the second person and third person. And I'm in control of all of them. That's why they don't delete my posts. I've already given them notice of the legal construction and who is owner and control. I control what I put on that platform. Lizzie Longtoes says hi. We got to Dr. D-Head. Philip Fairweather says assumed name game. Yes. Who is that letter order disorder recorder? It's a paper mache compost position. Yeah, you've undertaken the decedent. You've become the coroner. You've determined that it is alive still. Grumpy T-Rex Smurf says, what are the forms that we can use to hold oath of office proving that we have no call office? There is no form. It's a declaratory statement. It's something you have to declare. It's something you have to know and put forth as a truth to rebut the presumption of facts on the record and make it a fact in law, whereas they only practice at law based on the presumptions presented to them. It says, learn how to cut paper corners, cut off part of the square, now hexagon gone. Lizzie says, good question. Like old folks home, I don't know the context because the comment was made earlier. 31 U.S.C. 51 or 5315, or no financial trade or business and partner, director, officer, employee of a domestic financial institution. And that's the important part, the partner. This is the partnership that mom and dad start when they get the, even if they're not married and they have a child, they partner up with the state with the enumeration at birth. Or if they do get married, they partner up with the state through the marriage license. It's a partnership. And yes, the video will be available as soon as I'm done. Give it time to load. It'll say this video not available, but it'll take a short time and it'll be right back up. 50 U.S.C. 1433, public records examined by the Comptroller General. Correct, because the error is a financial error. We've been reasonably believed to be an eligible contract participant functioning in a similar way as a financial institution by acting similarly on the other side of the counter as the financial institutions. Yes, agree on the diplomatic passport. You've got to learn how to be diplomatic. And this is why I talk about the high school diploma. They did not teach you proper etiquette at the international level. They taught you proper etiquette to make you a slave at the local level so that the community has no power whatsoever. Only the community, quote, leaders do. And they lead through the power of taking your power through the records. You're giving those data elements and don't understand the power of those data elements as one of the people. So anyway, yes, hit the like, share, and subscribe. I want to thank everybody for joining me today. I'm going to be back later on with a friend of mine, hopefully, if not today, tomorrow, to do some explanation about the Postal Service setting up a P.O. box, assigning them as the trustee to reconcile the out of balance account, as they're the ones that are supposed to do that in reconciling the general ledger. So we're just a matter of trying to get away from the administrative record maintenance and putting the record in its proper place so that it can be maintained by the proper financial institution, the United States Postal Service. As we saw. And that'll be, we'll be talking about how they have a contract with the Selective Service, because again, that's where you go to apply, to register for Selective Service is the post office, guys. Same place you go to get that passport. So what we're doing is we're returning just solely, just sanguine back to our inherent capacity as the civilian commander, not an officer or agent of the military corporate construct. We're retiring, but keeping the record open through an open directive for full acquittance and discharge, where no person shall be held liable in any court. Owe no man anything but to love one another, for to love one another is to fulfill the peace, or is to fulfill the law, which is peace, not war. Trading with the enemy. Get rid of the me, the name. It's not yours. It's hearsay. So remember, folks, I love you. But I had to remind my companion even here recently, I don't give one fuck whether you love me back. As to say, I don't care if you hate me. I don't care if you don't respect me. That's on you. So may God bless you. and have a good night. Please hit that like, share, and subscribe button. There's a PayPal link there for anybody who wants to share some love. All is appreciated. And we'll see you again next time. Bye now.